The issuance of licenses, be it restaurant, rum shop, occasional liquor or otherwise, does not necessarily require the services of a magistrate per se. With a minor amendment to the law, the revenue offices in the various districts can deal with these applications without involving the courts. When the application for a particular license is filed, it is sent to the police, the health and the fire service for them to investigate. If there is no objection, the premises can be visited by a special committee appointed under law, and once the premises are in an acceptable condition, the license can be granted through the revenue office. If there is an objection, which seldom occurs, then the matter can be dealt with by the court. In one fell swoop, so to speak, the magistrate is relieved of having to deal with thousands of applications for which there is no objection. In this way, considerable judicial time is saved. Having thus unclogged the system to some extent, we can then implement rules of court that will ensure that a case proceeds through the system in a similar way to that of the assizes. The result will be that when a matter is before the court, it is there for a specific purpose and not for an adjournment. During these stages at which the accused must be present with his attorney, unless on remand, there will be no need for witnesses to attend. The prosecutor will take charge of the case so that the complainant will not necessarily have to attend. This will have the effect of freeing up police officers from having to attend court unnecessarily, thereby allowing them to spend more productive time in determining crime and performing other police duties. As for the accused on remand, the question of video conferencing from the prison, where he can participate in the case management, must be examined. I understand that this procedure works quite well in the United Kingdom. It may be that the legislative underpinning is required, but this proactive approach will certainly change the way business is done in our courts today. Draft rules have been in existence for some time, but have remained dormant. Recently, I had the opportunity to peruse certain rules that were prepared by the courts in the OECS, where, incidentally, the preliminary inquiry is to be replaced by a similar procedure described a moment ago. Other jurisdictions, for example in the United Kingdom, have already abolished the preliminary inquiry and introduced a system similar to the one outlined above. Magistrates, or at least some of them, have had the opportunity of perusing these rules, and while in agreement in principle with them, we need to have certain amendments that will fit our jurisdiction. Shortly, I propose calling on the Law Association, the Criminal Bar Association, the Assembly of Southern Lawyers, Tobago Lawyers Association, the panel of officers from the DPP's department to meet for the purpose of discussing case management rules for both the assizes and the magistrates' court. The response will be a sure sign that we are willing to work together for better administration of justice. I'm reminded of a slogan that I saw the other day on the back of a t-shirt, and it read as follows: "Tell me and I will forget, show me and I may remember, but involve me and I'll be committed forever." While we may not have the advantage of starting from scratch, like the family court, we have the benefit of its experience and what has contributed to its success. While I may seem to be harping on the traffic courts, there's good reason for that. In a recent article written by William Lucy Smith, in which a continued carnage on our roads was addressed, the author had this to say: "Many commentators have lamented the extraordinary carnage on the roads, which is primarily caused by excessive speed, alcohol, poor vehicle maintenance, and poor driving skills. Behind this is the wanton disregard for road traffic laws and contempt for the police and the judicial system. These agents have apparently abdicated responsibility for the enforcement of traffic laws." End of quotation. The writer compared our disregard for law and order with the respect shown for the law in the United Kingdom. He made particular reference to the introduction of a designated driver after the consumption of much alcohol at a function, simply because the United Kingdom had been able to develop a culture of respect for traffic laws and the police, created by a policy of strict and effective law enforcement. The breathalyzer law is about to be introduced here, and this is an opportunity to put in place a system that will begin changing the prevailing culture of disregard for law and authority. This change is a necessary step if we are to truly enjoy peace and freedom in our country.